Lockdown is gradually drawing to a close, and for many businesses, that means planning for the new employees to return to work. However, this will not be a return to normal. Businesses will need to implement different working practices to ensure the well-being of their workforce and prevent further COVID-19 infections. A return to work will require business to address a whole range of issues. Some of these will be practical, such as implementing social distancing measures at work, providing PPE, and ensuring regular deep cleaning of facilities. However, what are the rights of the employer and the employee in the eyes of the law in this new normal? I'm very pleased to say that I'm joined by David Ludlow, a partner at Moore Barlow, who partner Woking Works. David heads up the employment law team, both for businesses and individuals. Thank you for joining us this morning, David, and giving up your time to provide us with your expertise. If you'd like to start with a brief summary of what the employment law issues that could be faced by both employers and employees when businesses return to the new normal.
Yes, thank you for having me. I think the starting point of any consideration of the employment law issues is to bear in mind that the government and Public Health England have designated COVID-19 coronavirus as a serious and imminent threat to public health. Those are the statutory words, and they are really the start and the end of all analysis in the different contexts of employment law that I will touch on. But when considering the return to work, I actually think that traditional problems, traditional employment law problems like reintegration to work, think of people who you've experienced over the years, employees on long-term sick leave, having to reintegrate them to the whole sort of work ethos, which will give rise to interesting employment law problems. I think that the sheer logistical exercise of deciding who's going to return to work from furlough or from working from home first is going to entail prioritizing and selecting. And whenever employers prioritize and select, they run into trouble, or there is potential for trouble unless they select fairly and lawfully. And we can come on to that. But broadly, if you think about the decisions that people have taken, employers have taken about designating who should go on furlough and who should remain at work, two broad approaches have been taken: the arbitrary sort of A team and B team, similarly compatible teams in terms of numbers and skills, just arbitrary A and B teams on rotation, or some kind of ABC prioritization. So in deciding on who and how people are going to return to work, I think that employers would be well advised to apply their mind to it and record their thinking, their decision-making process, and probably do it in some way like this: that category A will be who needs to be in the office for our undertaking to continue or to resume, who needs to be in the office, who would benefit from being in the office, of those workers who are not currently in the office, who would actually benefit from being in the office. And C, group C, who does not feel safe in the office or is not safe to return because they're shielding or they've got caring responsibilities for somebody who is shielding, or they've got children at school and so on. So that's the second issue, prioritization of those returning. The third employment law issue, I think, is what are your contractual powers as an employer? What does the contract say? What does your agreement with your people, your bargain say? Can employers expect, or what can employers expect their employees to do and not to do, which is also a very, very interesting issue. If you think about this interesting French case that's been reported overnight, the perfume worker who sued a famous French perfume house for £30,000, 30,000 euros successfully, on the grounds that he didn't have anything to do. He was bored. He was doing 40 minutes work a day only. It's a very interesting case because it's groundbreaking anyway, in a sense, in terms of European law. But of course, those who have been furloughed are probably bored, large numbers of them. But what is interesting is whether people who return to work, will actually be given their contractual entitlement. In other words, the right to work. If you think about, what is redundancy? Redundancy is the purest form of repudiation of the employment contract, because the employer doesn't give the employee sufficient work to do. So they're redundant, so they can in its most extreme form, they can walk out and claim constructive redundancy, constructive unfair redundancy. So that's a very interesting issue. But perhaps the most pressing issue, employment law issue, of what are employees' rights to safety at work, and what are employers' duties? Well, you often hear employers and commentators talk about the duty of care that employers own, and sometimes employers owe. Sometimes the duty, the so-called duty of care, is very sort of imaginative, and but what is certain is that employers owe a basic common law duty of care to provide a safe place of work and safe methods of production, and competent and fit colleagues to work alongside them. So if an employer requires, as they will do, employees to come back to work, they must take steps to protect them against foreseeable risks to their health. The common law duty of care, and we'll come back to the practical steps that employers must take to do that. It's not just physical risk, catching coronavirus, it's also the mental risk of the sheer stress and anxiety surrounding the possibility of catching coronavirus, and other stresses that are introduced by the disruption and the impact of coronavirus on the workplace. And then, quite apart from the common law duties, there are very specific statutory duties under the health and safety at work legislation, of course. There's a myriad of rights and duties under the management of health and safety at work regulations, under, for example, the PPE, the personal protective equipment regulations of 1992, but also under things that are less obvious, like the control of substances that are hazardous to health regulations. Coronavirus is such a substance, believe it or not, that is hazardous to health. And so those regulations, the 2002 regulations, that they require an employer to ensure that employees are not brought into contact with with the public, with customers who are infected. Not so obvious, that one, but it's definitely applicable and a serious issue. So all employers are going to be required to do risk assessments. And you know, the word risk assessment trips off the tongue easily. We often use the expression practitioners, employment lawyers, HR professionals, employers, we must do a risk assessment. How do you do a risk assessment? And it's not actually that difficult to do an effective, lawful risk assessment under the common law duty or under the specific statutory duty. You know, in a sense, the employer has to merely apply their minds seriously to the risks and take such reasonably practical steps as they can to alleviate the risks. But actually, when you drill down, if you ever get involved in an employer liability case, and you drill down to what it means and proving that you've taken those steps, the risk assessment must, for example, be of appropriate quality and not just address obvious risks. The employer has to go beyond applying its mind to just obvious risks. So when we're contemplating a second wave of coronavirus, you know, we really need to think about those words, reasonably practicable steps and measures, what that means. And then, of course, other issues are contractual sick pay entitlements. Statutory sick pay entitlements has featured heavily, you know, in our deliberations over the management of coronavirus in the workplace and at home, of course. Whistleblowing, that employees and workers, by the way, who may not be fully fledged employees, so-called Lim 1B workers, they are going to, if they are concerned about a possible breach of legal duty on the part of the employer in not providing a safe place of work, they are going to effectively blow the whistle or be tempted to blow the whistle, and they may do it in a technically correct way, which complies with the very complex legislation, the Public Interest Disclosure Act, or they might do it in sort of fairly public and drastic ways if, for example, they believe that there is a serious risk to health and safety. They might purport to blow the whistle on Twitter or on social media and still be protected from detriment from whistleblowing. Just think about that possibility. So all sorts of duties are going to arise quite quickly for the employer in relation to anybody who purports to blow the whistle. And similarly, think about the specific health and the so-called health and safety protection from detriment and protection from dismissal that employees who remove themselves from what they regard as, if they reasonably regard it as an unsafe place of work, will be protected from detriment, including ultimately dismissal. That they will be entitled to bring what we call detriment claims, where they've been sort of disciplined or subject to some detriment short of dismissal, but also automatic unfair dismissal claims if they have walked out and claimed constructive dismissal, or they have been dismissed because they had the temerity to complain and draw to the attention of the employer what they genuinely, honestly, reasonably believe to be an unsafe place of work, an unsafe environment. So we've got that whole area. And then finally, I would say that you're going to get people invoking their family rights, their family related employment law rights. That is to say, the right to unpaid parental leave if they feel that it is necessary for them to stay at home to look after children, for example, or more drastically, emergency dependent care leave. So that is an overview of the employment law issues that I think are going to affect us in practice as workers, as employees return to work.
Thank you very much, David. Very insightful. I do have a few questions for you, if I may. Um, when when employers are thinking of bringing staff back from furlough leave, and they feel that redundancies are necessary, Martin Pocock also had a question relating to this. How does an employer make a furloughed staff redundant?
Well, you can, of course, make furloughed staff redundant. You have to inform and consult with them individually and possibly collectively if you're contemplating or propose to make more than 20 people redundant, whether they're all furloughed or some are furloughed and some are working. But if you are proposing to make 20 or more people redundant, then you have to go through a collective consultation and information exercise through appropriate representatives, i.e. trade unions, if it's a recognised trade union workforce, or elected representatives. But the short answer is that that employers can move to make furloughed employees redundant. They have to inform and consult. Of course, in informing and consulting with furloughed employees, the employee is not working. There's no rule of law that says if you inform and consult with a furloughed employee about the possibility of redundancy, you are thereby undermining the entitlement to reimbursement or a grant under the job retention scheme, under the coronavirus job retention scheme. You have to think carefully about the timing, as you do anyway with staff, with employees who are not furloughed and who are working from home or are working in their normal workplace in the offices. I think, in relation to redundancy, of course, what businesses should and in practice will do and have already started doing is consider all of the alternatives to redundancy, because redundancy is a drastic and often, or at least sometimes, counterproductive, damaging step to take, because you lose skills, and in a sense with people you have to start again. So there are all sorts of measures and steps that employers can and are now across. I know the businesses I represent across a wide range of industries are all responding to this challenge differently. Some are contemplating and actually effecting redundancies. Others are working hard and imaginatively to keep their people on board. So, for example, as alternatives to redundancy, what about temporary reduction in pay? What about short time working, layoff? You know, that you see that in more industrial environments, in manufacturing environments, or in hospitality, for example, where there are existing sort of layoff short-term working powers in the contract of employment. Think about flexible working arrangements. Um, Flexible working arrangements don't have to be permanent. They can be temporary and terminable on reasonable notice. But, you know, in the current climate, probably a very sensible thing to do, particularly with the very clever, in my opinion, or very well thought through flexible furloughing scheme that the government's come up with that we'll come back to later. Think about early retirement as an alternative. Check the pension scheme, the employer's pension scheme. Don't fall into the elephant trap of effecting compulsory early retirements, which will be dismissals and unfair and probably discriminatory in terms of age. Think about delaying bonuses, the payment of bonuses. Think about sabbaticals. You know, whether you call it a good old-fashioned sabbatical or you call it unpaid leave, doesn't matter, because it's just something you do through agreement. You know, can be quite attractive to somebody depending on their stage of the career they're at. Think about the withdrawal of non-contractual benefits as a way of saving money, you know, which you can do at a stroke. And think, of course, as businesses are up and down the country, of annual leave holiday requiring not just people at work working from home, working in the office, but also furloughed employees to take their holiday, and we can touch on that in more detail. But those are the sort of thoughts that one has whenever anybody says redundancy.
Thank you, David. We've got a question from Kevin Davis. Has there been any relaxation of any of the employment laws brought in by the government, either temporary or permanently, due to the coronavirus that you might know of?
No, there hasn't been any repeal or suspension of employment laws per se. So, you know, the full panoply of statutory and common law employment law is still out there and has to be navigated. But, you know, the coronavirus job retention scheme, I suppose, you know, has effectively disapplied, in a sense, you know, some contractual employment laws in that, you know, it has, to all intents and purposes, enabled employers to designate, to use the words of the coronavirus job retention scheme, the furlough scheme, designate people as furlough and thereby retain them as employees without formally laying them off, you know, under the old Section 155, you know, the archaic statutory layoff provisions. And you require them not to work. But, you know, really just thinking aloud, at the end of the day, when you designate somebody furlough, you know, as people will be next week in July, in the first week of July, on a flexible basis, basically you need agreement, but you quickly reach agreement, of course. that it is essentially a consensual process. You need agreement in writing when you designate somebody to go on furlough, so that you don't unlawfully deduct their wages. No, that there hasn't been any repeal or suspension of employment laws.
Thank you, David. I hope that's answered your question, Kevin. Got a couple of other questions. Shops are required to produce a COVID-19 risk assessment, as you discussed earlier, and display what measures they have taken to keep their premises safe for their customers. Do offices and other workplaces need to do the same?
Yes, they do, because the government has urged them to do so. But they do actually, because Regulation 10 of the Health and Safety at Work, Management of Health and Safety at Work regulations effectively requires them to do that, because those regulations require, in a context in which Regulation 3 requires a risk assessment, those regulations require the employer to provide information about the risk assessment and the measures that the employer is going to take to the staff, to the employer, and also to those affected by the way in which the undertaking is run. So, if you take a firm of solicitors, for example, that opens its doors, it's not only got to prominently sort of display its approach to the management of COVID-19 risk for its staff, but also its visitors.
Am I right in thinking that businesses of 5 employees or more were obliged to write a risk assessment, and is it now changed that every single business has to? Or am I wrong?
Well, you could well be right. That does ring a bell, the small employers exemption, but in the context of COVID-19, any small employer of less than 5 employees would be well advised to comply with Regulation 10 that I've just outlined, and also to follow the government's pretty clear guidance on it. Yeah.
As an employee, what are my rights if I feel the office where I work is not meeting hygiene or social distancing levels that I expect, i.e. the employer has implemented limited social distancing measures or not provided any PPE? Can I refuse to go back to the office?
Yes, it is the short answer that the reason for that is that if the employee, if you are right about that, and that the employer has really refused to, I think you said provide PPE. So, of course, except in certain industries, sort of controversially at the moment, as the rules stand, that there are very limited duties on employers generally to provide PPE. Of course, those employers who have to will be or should be familiar with the 1992 regulations, the PPE regulations, and there is nothing to stop an employer who carries out a risk assessment and takes a sort of proactive or progressive view of their duties to issue PPE. But if an employee honestly, reasonably takes the view that the employer should be issuing certain personal protection equipment, or should be taking other measures to make the workplace safe in their view, and is not taking such measures, then the employee can rely on their rights under Section 44 of the Employment Rights Act, the right to be protected from detriment, and Section 100, the right to be protected from automatic unfair dismissal, and remove themselves from an unsafe place of work, or refuse to attend work. The employer's got to be careful about the way in which they respond. That what they mustn't do is knee-jerk reaction, dismissal, or subject the employee to any other detriment because they've had the temerity to suggest that the measures that have been taken are inadequate, because that will result in liability. For his or her part, the employee does not have sort of carte blanche, because they have to sort of reasonably believe that it's an unsafe place of work. And ultimately, if you fast forward to a tribunal, which you have to work out what will happen at a tribunal to ascertain who's right and who's wrong, what the answer is. But of course, the tribunal is going to ask itself whether the employee acted reasonably, whether they reasonably believed there to be a risk, and will also have regard to the response that the employer actually gives as a matter of fact, and amongst other things, has to ask itself whether the employee has acted negligently in his or her actions, and thereby caused or given rise to a risk of negligence that could cause loss to the employer. So there are statutory provisions there, very well established, and I mentioned earlier whistleblowing, and also, of course, there is good old-fashioned common law breach of contract. If the employee raises a grievance, or the employee draws what he or she believes to be shortcomings in health and safety at work management on the part of the employer, and the employer does not treat that seriously, then they could be in breach of contract, whether or not they are in breach of the very specific statutory duties that I've outlined. For example, they could be in breach of the implied term of trust and confidence, if they conduct themselves in a way which is calculated to destroy the relationship of trust and confidence, or more likely, if they conduct themselves in a way which is likely to destroy the relationship of trust and confidence with the employee. So in those circumstances, employees will be contemplating walking out and leaving and claiming constructive dismissal, and so employers have to guard against that possibility.
Thank you, David. Liz King has asked a question as a follow-up to that. How about if an employee feels unsafe to return to work, but cannot give a rational reason as to why, and could be related to mental health issues?
Yeah, very interesting. So possibility arises of them suffering from a mental impairment, and thereby being disabled, and protected because they're disabled, and so the employer, for that reason alone, it is under a duty to ascertain the true medical picture, in fact, before they can do anything, because COVID-19, coronavirus or not, if the employee is suffering from a mental impairment that has an adverse effect on their day-to-day ability to carry out normal activities, blah blah blah, they are disabled. So that gives rise to the duty to make reasonable adjustments, and it affords the employee ultimately protection from dismissal, whether or not they've got 2 years continuous service. So that is the first thing, but also in considering whether they are invoking their rights under Section 44, as I outlined earlier, their health and safety rights under the Employment Rights Act, and indeed their common law rights to raise a grievance, of course, or to draw to their employer an unsafe system of work. The employer has to take into account the possibility that they are not just unwell, but that they are disabled, quite apart from having to take into account that they may very well reasonably believe, albeit that they are wrong, that adequate measures have not been taken. And so, as ever, information, consultation, proactive information, consultation, liaison is the key to managing that situation safely.
One could also assume that we'd hope they'd consult their GP and or HR department and have other advice as to returning to work, maybe signed off. I know of examples of people who are genuinely scared of leaving the house for fear of catching the virus, and as an employer, it must be very difficult to manage that situation if that's the reason. But I presume a lot of employers will be sympathetic to that situation.
Yeah, I mean, huge responsibility and role for HR, human resource managers, professional. If you haven't got in-house HR capability, there are a lot of very good HR consultants out there who you can take advice from on an ad hoc basis, and really ask them to manage the situation. But ascertaining the true medical picture is more than half the game, and that certainly entails considering so-called statements of fitness to work, which really means statements of fitness not to work, and any other information, including, it's always worth bearing in mind, the information that the employee, him or herself, can be reasonably required to provide, because it's a two-way street consultation. And employees who insist or represent that that they're scared or worried about coming back to the workplace are under a duty to cooperate. They also have to proactively inform, liaise, communicate with their employers, which we all know, if you've managed long-term sickness problems, it is very often, you know, one of the big challenges that employers face.
Yeah. I've got a question from Clive Stone, who's asking if an employee refuses to travel into work on public transport, assuming that was their only method of getting into work, can the employer insist that they attend the office?
Yeah, it's a very topical, common problem, actually. I've dealt with 2 or 3 situations. I had a client uh, running a laboratory in Guildford, in fact, where they could only function and operate if the laboratory workers actually came into the laboratory, because they couldn't do their work at home. It was impossible. And some of them lived a long way away, but relatively long, a good commuting distance away. And in fact, we're used to commuting to Guildford by train. And, you know, understandably perhaps refused to commute because of their perception of the heightened risk of catching coronavirus on the train. Of course, at that time, a few weeks ago, I think the government's requirement for masks on public transport comes into effect on Monday, I think. But you know, the employer's got to be careful that, but the employer can take the initiative and manage the situation by, for example, offering to arrange for a taxi, offering to provide or facilitate hire car, offering to pay for the exceptional costs of first class travel. It could be as simple as that, the solution. That what the employer has to do, you know, quite apart from the practical challenge of getting the worker into the workplace, which is necessary for the business to carry on functioning, you know, but to protect themselves from the possibility of a constructive dismissal claim, and to put themselves, you know, in the driving seat, so to speak, in managing the problem, the employer should proactively make suggestions of that sort, and in doing so, inform and consult with the employee about the problem. And you know, if the employee says no, I still think it's too risky to come in on a taxi, or you know, no, I can drive, but I haven't driven for years, and I don't want to drive from London to Guildford, or puts up resistance, then quite quickly, if the employer concludes that it is necessary to terminate the employment of that employee, they will be able to defend any claim, you know, possibly redundancy, but possibly incapacity, incapability, but probably on the grounds of what we call some other substantial reason, because there is a real problem there. And a lot of these employers, you know, are running out of money fast. And, you know, in the example I gave you, that finding the money for a taxi or a hire car was quite a challenge, actually. You know, in the event that problem has been managed imaginatively, but believe it or not, by way of a part-time and fixed-term arrangement. But you know, so there are solutions to these problems. Absolutely critical is consultation.